Hello, welcome to the expert witness training for the MEC for Health Eastern Cape versus AAS on behalf of SS. Before we get into the case itself, there are just one or two preliminary points that I'd like to make. This case is important because it gets to the heart of the way in which the courts should assess expert evidence. The approach which we're going to take to the case in this video is we're going to do a deep analysis of this case. So we're really going to, because of the audience, the expert witnesses, we're going to go into the medical facts. I will also take you through the procedural aspects, which I'll make clear to you as we walk along through this judgment step by step. And those two factors will serve really as a backdrop to what is critical about this case, and that is the court's approach to the proper assessment of expert witness evidence in circumstances where a joint minute has been signed by experts. Now, it's very important that a proper understanding is gained of what happens when a joint minute is signed. What is the mechanism? And you'll see this case is a very good example. Now, strong judgment, clear judgment, in my view, good authority for the proposition set out in the judgment, and it will give a good foundational understanding to joint minutes and what's with the mechanics around a joint minute. There's a reference to one case, which is B. B is a very well-known judgment. This judgment, in a way, builds off B, but this judgment is very recent. It's been handed down within the last week. So we're going to look at this judgment. You don't need to understand B in order to understand this judgment. However, I will do a deep dive analysis on B within the next few weeks. And that then brings me to the last preparatory point, and that is that this video forms part of the course material for the current awareness training for expert witnesses. The point of the current awareness training is to allow expert witnesses to understand what is currently going on in the law. So as the judgments produce cases which are relevant to expert witness evidence, we will pick up on those cases. As we go through the cases, we will then start being exposed more and more to additional principles that come up in those cases. This is a very good example. And so the idea behind the current awareness training is that what you do is you walk through the current cases as they come out from the courts, and that will then start building a picture step by step, so you get a double benefit. You're on top of the latest developments of the law, and as you develop over time, you're going to get a deeper and richer understanding of the context in which expert witness reports are written and the context in which expert evidence is presented. Those are my preparatory remarks. Let's have a look at MEC for Health Eastern Cape versus AS on behalf of SS, and it is a judgment of the Supreme Court of Appeal. Hello and welcome to a deep analysis of MEC for Health Eastern Cape versus AS on behalf of SS, judgment of the Supreme Court of Appeal. We've got 25 slides to get through. I expect that it will probably take me about half an hour to present this case analysis. Some of those slides are quite full. I will keep my image in the bottom right-hand corner of the case, and I will try to then talk you through it as if it interferes with the text. But anyway, without further ado, let's get into this. Let's start off. Let's have a look at the case heading: MEC for Health Eastern Cape versus AS on behalf of OS. First, it's interesting because the first party mentioned is the MEC for Health Eastern Cape. Normally, when the case is initially brought, the plaintiff would have been AS on behalf of SS. I'll get to the naming of the respondent in this case in a moment. But you'll see that the reason why the MEC for Health Eastern Cape was cited first is because the MEC for Health Eastern Cape was in fact the appellant in this matter. In other words, the MEC for Health Eastern Cape had lost in the court below and had now been given leave to appeal this judgment, and now the judgment was being dealt with the MEC for Health Eastern Cape bringing this portion of the matter before court. Therefore, her name is first, and then versus AS on behalf of SS. That's interesting what that tells you. Those initials, AS, is, let's start with OBO, on behalf of. It's short for on behalf of. And that is used when a guardian, usually a parent, but not necessarily, brings a case on behalf of a minor child. The other indication that this is being brought on behalf of a minor child is the fact that the initials are being used. In other words, there's anonymity in this case, and that applies when the courts deal with cases in South Africa dealing with minor children. So from that heading, I can immediately see that it looks to me as if this is an appeal judgment brought against a plaintiff who was a minor child and had his or her case brought on behalf of that minor child. We also sometimes see ATS, which is at the suit of, that's another abbreviation, or sometimes with minors we will see duly assisted by. You needn't be too concerned with that at the moment. I'll just mention that in passing. Then we've got the case citation. That is a South African Medico Legal Reports case citation, 2025 judgment, ZA-SCA, in other words, ZA South Africa, SCA Supreme Court of Appeal, 15th of January 2025 is when the judgment was handed down. And so that is a very recent case. As I prepare this video, we are on the 22nd of January, so it's not even a week old, that judgment, so hot off the press. Why is this case important? This is specifically aimed for expert witnesses. There are other reasons why it's important for lawyers, but for expert witnesses, it considers the correct approach to evaluation of joint minutes of experts. Now, as I said in the introductory video, the specific principles related to joint minutes is obviously very important. The moment when expert witnesses sign a joint minute, it has potentially far-reaching legal consequences. And it is very important for expert witnesses to know what they're doing when they sign a joint minute, and this case will assist in gaining that understanding. The relevant practice notes, I'm referring here to practice notes of the South African Medico Legal Reports. They are available on the website to subscribers. If you are watching this video, you are probably a subscriber. You may be enjoying your free trial period, in which case you will still have access to those practice notes. If you go to the practice notes, you will see from the table of contents, reliance on joint minutes of experts. That practice note will give the context of that particular topic. I'm not sure whether there are other cases which deal with that point yet, but certainly you'll find a summary of the key points of this judgment contained in that practice note. The idea behind the practice notes is to accumulate all that information, have it available in one place for you to go to and look at if necessary. Now, background reading. Before we move off the practice notes, my apologies, you will find that under expert witnesses, and then there's a subsection which deals with the reliance on joint minutes of experts. Let's have a look at background reading. This gives you the different sections of the judgment. What I would recommend is watch this video and then go back and have a look at those sections of the judgment just to familiarize yourself with the details. What I sometimes do with the videos, I will take the background and I will just summarize it and won't really go into the background and leave it to the participants to go and read those paragraphs for themselves. But my approach with expert witnesses is that I do feel that I need to guide you a little bit on the background and just assisting you just to make your way through a judgment. So for that reason, I'm not going to just leave you to do the background. I will assist you through that. And then the other points, of course, you've got the factual background at paragraphs 27 to 32. We will go through them in this video. And then reliance on joint minutes of experts. Right, let's get into the matter. So the subject matter of the appeal, so it was an appeal judgment, and in fact it was an appeal judgment to the Supreme Court of Appeal. The Supreme Court of Appeal is the second highest court. The only higher court is the Constitutional Court. Generally speaking, the Supreme Court of Appeal is the last word on a particular matter. It is also not important to realize that an appeal in South Africa is not just there as a right, automatic right. You have to convince the court who's handed down the judgment that there are reasonable prospects of success on appeal before they will give you what we call leave to appeal. So you have to make out a case that there's a valid basis for appealing the judgment, and you have to convince the same judge or judges that they should give you leave to appeal. So it's questionable whether that's an ideal situation. But anyway, that is the legal position in South Africa. Now let's look at the matter. The subject matter of the appeal was a medical negligence claim arising from the conduct of medical staff employed by the appellant, the member of the Executive Council for Health Eastern Cape. That's the MEC. We saw that. That was the appellant. Before and or during the birth by the respondent, Miss S, of her child, SS, at the St. Barnabas Hospital, St. Barnabas, in the Eastern Cape in 2012. So Miss S instituted the claim on behalf of SS. There we go, as I said in the heading. So Miss S brought the claim on behalf of her minor child. Why? The minor child doesn't have what we call locus standi, doesn't yet have full mental capacity and legal standing to bring the claim. It needs to be assisted by a person with full legal standing. In this case, Miss S was the mother, so was the legal guardian of the child and had legal standing to bring the case on behalf of the minor. And we see the sentence there finishes who was a minor. So SS is the minor. Miss S is the mother, who will also be involved in the facts of this case. And then initially the defendant, when at trial stage, that was the member of the Executive Council for Health Eastern Cape, but was now the applicant or the appellant, more correctly, before the Supreme Court of Appeal. The Eastern Cape Division of the High Court Mthatha, the trial court, that's where the initial trial is held. Now, normally for expert witnesses, you'll go to trial court when you appear, when you're called, if you go to court and you have to go there with your file and get ready to get cross-examined, that's the trial court. Once the matter's finished in the trial court, there's no more oral evidence, and the matter then goes on appeal, and everything is decided, what we say, on the record, in other words, on the papers. That will become very important in this case, is the preparation of the record, etc. I can't remember to what extent I included the problems with the manner in which this appeal was brought, but there were significant problems, and a lot of those problems related to the preparation and handling of the record, which is then obviously the written record of what would happen at the trial court. And that is why, as an expert witness, you will not appear in appeal hearings. That is argued in court simply on the papers. In any event, Ms. S's appeal to the full court succeeded. So what happened is there was a trial. Ms. S lost that case and then appealed to the full court. The full court is a 3-judge bench, also known as a full bench. So 3 judges decided that the appeal should be successful, and the MEC was ordered to pay such damages as would be proven consequent on the hypoxic ischemic encephalopathy and brain injury sustained by SS, the minor, as a result of the medical negligence of the medical staff. So this is an HIE case, and we will see the court will make 1 or 2 remarks about HIE cases. Generally, the MEC was granted leave to further appeal the full court's order and judgment to the Supreme Court of Appeal. So once again, leave was granted to appeal further, and now the matter was going up to a very senior court, the Supreme Court of Appeal. I said that there would be some comments on cerebral palsy cases. Here they are. The Supreme Court of Appeal commented that medical negligence claims linked to cerebral palsy in newborns are increasingly prolific in our courts. They often involve complex questions around negligence and, in particular, causation. Very important. Causation becoming more and more an issue in these cases. The present case was no exception. Complicating matters further were multiple failings on the part of the plaintiff's attorney to comply with the relevant uniform rules of court regulating the appeal from the trial court to the full court. The Supreme Court of Appeal considered the plaintiff's attorney's handling of the appeal procedure and concluded that there was a flagrant and gross failing to comply with the uniform rules of court on the part of the plaintiff's attorney. These failings raised the important initial question of whether the full court erred in overlooking these failings. So, what happened? There was a trial. There was then an appeal to the full court. The procedure for handling appeals is set out in the Uniform Rules of Court. The Uniform Rules of Court govern the procedure in the high courts in South Africa. There are specific requirements relating inter alia to putting up security for costs and dealing with the record, which the plaintiff's attorney in this case, which was the appellant's attorney before the full court, failed to observe. And in fact, those failures were so bad that they were regarded as flagrant and gross. Now, what's important for the reasoning in this judgment, so the little golden thread that runs through the judgment is the reasoning of the court. What's important for the reasoning of the court in this judgment is that the court then puts up that last sentence, very significant. These failings raise the important initial question of whether the full court erred in overlooking these failings. In fact, in the judgment, it talks about the anterior question. In other words, the first question that the court should ask before even getting into a decision about whether the appeal should succeed or not is whether these failings by the plaintiff's attorney in the manner in which the appeal was prosecuted should be overlooked. Then the Supreme Court of Appeal went on to say the High Court has the right to grant condonation for a failure to comply with the rules of court where the interests of justice demand this. In other words, it does happen that attorneys don't comply with the rules of court for a whole variety of reasons, some of them innocent, some of them, as you can see, for completely unacceptable reasons. But where there's been a failure to comply with the rules of court and the interests of justice demanded, the court can condone non-compliance. In other words, it can say, that's fine, we excuse this non-compliance. This does become relevant to expert witness practice because, as you know, there are rules governing the way that expert reports are prepared and presented and the way that expert evidence generally is handled in the courts. There's specific sub-rules dealing with that and there's case law on it. That will come up during this current awareness process, I can assure you. For now, I'll just make the point, we can revisit that at a later date, but be aware that the uniform rules of court govern the manner in which High Court cases are conducted. It is important to familiarize yourself with the relevant concepts and cases in order to navigate your way through this type of situation. A party seeking condonation must give a full explanation for the failure to comply with the rules, and this explanation must be reasonable. The court must weigh all relevant factors, including, depending on the facts of each case, the degree of non-compliance, the explanation, therefore, the importance of the case, the avoidance of unnecessary delays in the administration of justice, and importantly, in this case, the prospects of success. Now, these factors are interrelated and must be weighed one against the other. So you'll see that there's a full investigation into why the uniform rules of court were not complied with. It's not something taken lightly, and the court must, what will also be relevant in this case, must look at all relevant factors. So there must be a broad inquiry. For example, a slight delay and a good explanation might compensate for weak prospects of success. However, in a case of flagrant or gross non-observance of the rules, a court may refuse condonation regardless of the prospects of success. Now, already there's a warning bell there because we've seen that the courts already found that in this case there was a flagrant disregard of the rules. And we'll see how that plays out in this case. Contrary to the tried and tested approach to condonation established over decades, the full court, this is the Supreme Court of Appeal talking now, and the Supreme Court of Appeal said that contrary to what should happen, the tried and tested approach, the full court considered only the plaintiff's prospects of success. In other words, it didn't consider these other factors. You'll see prospects of success, but look at all these other factors. Degree of non-compliance, the explanation for non-compliance, the importance of the case, the avoidance of unnecessary delays in the administration of justice, all come into the picture and should be considered. Now, what happened is that the full court found that the prospects of success as being so strong that it found in favor of Ms. S and effectively condoned the non-compliance with the rules of court. Now, just to make a point there, so what was critical to the decision in the Supreme Court of Appeal was, should we allow this non-observance of the rules to stand? Should we condone the non-compliance, or should we refuse to hear the case? And then the full court considered the prospects of success and came to the conclusion that the plaintiff's prospects of success were so strong that it was going to condone the non-compliance with the rules of court. In other words, regardless of the fact that the proper appeal procedure was not followed, because there were such good prospects of success, the court was prepared to hear the case and to come to a conclusion. Now, the Supreme Court of Appeal, now considering the full court's decision, held that in adopting this approach, the full court failed to exercise its discretion judicially or at all. In other words, the court had a wide discretion. It's got a wide range of scope within which it can make a decision. It's also very important in law. But that discretion must be exercised, what we say, judicially. In other words, must be correctly exercised. So although the court's got freedom to make decisions, it must be correctly done. And the Supreme Court of Appeal found that the full court did not exercise its discretion judicially. The question to be considered by the Supreme Court of Appeal was whether the appeal ought to have been struck from the full court's roll. Struck from the roll, not even heard. We refuse to hear this matter. You haven't followed the correct appeal procedure. We're not going to hear this matter. In Afrikaans, they say, van die hand gewys. The Supreme Court of Appeal therefore completed the exercise that the full court failed to undertake properly and to weigh the prospects of success against these other factors set out above. The Supreme Court of Appeal then proceeded to consider the total body of evidence. This is going to become important in this case. Was the full court correct in its assessment regarding the plaintiff's prospects of success? Crucial question. If not, there could have been no justification for its decision not to strike the matter from the roll. Put differently, if the prospects of success were not strong, then the matter must have been or should have been struck from the roll and not heard at all. Then the Supreme Court of Appeal said this question required a consideration of the facts and merits of the case. Let's have a look at the facts. I have set out those paragraphs where you can find the facts. But let's have a look at them since the audience is of expert witnesses. I think you would find this interesting. The relevant facts were largely common cause, in other words, largely agreed. Miss S was 17 years old when she was referred from the local clinic to St. Barnabas at approximately 9:30 at night on the 25th of December 2012. She was in labor and was examined by the nursing staff at 21:34, so that's 2 minutes later. They noted that her cervix was 8 centimeters dilated. Her clinical records also showed that the fetal heart rate was measured as deceleration mixed and lasting, indicating some fetal distress. The caput or head measurement was double plus, pointing to obstruction in the pelvic canal. At this stage, there was only one doctor on duty at the hospital, a Dr. Madikane. She was already in theatre, putting up a chest drain in another patient, and was only able to examine Miss S at 22:50. So that's, just over 45 minutes later. On the available evidence, it was common cause that the nursing staff conducted no further fetal heart rate monitoring on Miss S, save for the first one on her admission. This failure formed the basis of the complaint that the nursing staff had been negligent in their care. The complaint was the fetal heart rate should have been consistently monitored. There are certain norms that apply. We won't get into that, but the complaint was that by simply not monitoring the fetal heart rate, that was an act of negligence which led to or caused the injury. There's the causation thing coming in. In light of the conclusion which the Supreme Court of Appeal reached on the element of causation, it was, however, not necessary to determine whether negligence was established in this respect. Let me just explain that. In other words, because now the court is going to make a finding on causation, which means that it doesn't have to find on negligence. Well, that tells us that the court is going to find that causation wasn't proved. Remember, it's not good enough just to have negligence. Very important concept. You have to have negligence which caused the injury or the harm. Harm and injury are interchangeable words, really, for our purposes. There has to be what's called that causal connection or the causal nexus. Simply proving negligence is not sufficient. And in fact, this case is very good illustration of that concept. Let's proceed with the facts. Dr. Madikane took the decision to prepare Ms. S for a cesarean section when she examined her. As this required 2 doctors, she telephoned the on-call doctor, Dr. Mlandu, who was not on site. Dr. Mlandu was at her lodgings in Mthatha, as the hospital did not have accommodation for its doctors on its premises. The trip from Mthatha to the hospital took about 30 to 40 minutes. Very important. Miss S had to be prepared for surgery, and the staff on duty had to explain to her what the procedure entailed for purposes of her consent. The theatre itself also had to be readied for surgery, and of course, Dr. Mlando had to arrive and prepare herself for the surgery as well. So there's a lot that had to happen, is the bottom line. A number of steps had to be taken here, all of which took time. The surgery commenced at 20 past 12. Dr. Marikane acted as the anaesthetist, with Dr. Mlando performing the caesarean surgery. Miss S was administered a spinal anesthetic. Unfortunately, she had an adverse reaction to this, becoming desaturated with her pulse dropping and her blood pressure reading 50/35. In common parlance, Miss S crashed and was in critical danger of cardiac arrest and death. A further consequence of her reaction was that the oxygen supply to the fetus was interrupted. You see, that's important. The decision was made for Dr. Mlando to halt the caesarean section in order to assist Dr. Marikane in resuscitating Miss S. They managed to do so, and when Miss S was stable, Dr. Marikane continued with and completed the caesarean. The hospital records show that the operation was completed at 20 past 1 on the 26th of December 2012. When SS was born, she had low APGAR scores and was subsequently diagnosed with cerebral palsy. The parties' respective radiologists agreed that the imaging features of her MRI brain scan showed features typical of an acute, profound, central, hypoxic ischemic injury pattern with no additional imaging features suggestive of a prolonged partial injury component. This was the cause of the cerebral palsy. Now let's have a look at, that's the factual background. Let's have a look at the plaintiff's case based on those facts, and the court will assess whether the plaintiff's case stands scrutiny or not. Reduced to its essence, Ms. S's case was that there was insufficient monitoring of the fetal heart rate from the time of admission to the time that the caesarean was performed. If conducted properly, signs of fetal distress would have been detected earlier. Other signs of fetal distress were apparent, requiring timeless delivery of the baby to avoid harm. The decision to perform a caesarean should have been made at 21:34. Instead, the surgery was delayed for 3 hours. Ms. S contended that the most likely cause of the brain injury was the untreated fetal distress and asphyxiation suffered by SS during the 3 hours before her delivery. The plaintiff had placed substantial reliance on the joint minutes of the obstetricians and pediatricians. We're now getting to the joint minutes. In the joint minutes of the obstetricians, it was recorded that it is common cause between them that the cerebral palsy most likely resulted from hypoxic ischemic encephalopathy, an obvious resultant brain damage due to fetal distress in labor that was not detected because of substandard fetal heart rate monitoring in labor. This conclusion, noted the full court, was in line with the pediatrician's joint minutes, in which it was agreed that the most likely time period of hypoxic ischemic brain injury was the peripartum period, i.e. the period shortly before, during, or immediately after delivery. Now, you might think that as a result of those joint minutes, the cadet quaestio, as we say, at end of case, there's nothing more to be said. I rest my case, as the Americans say in the movies. Not so, and we'll see why. The Supreme Court of Appeal held that what the full court failed to appreciate was the distinction that must be drawn between factual evidence given by expert witnesses and their opinions. Now we're getting to the heart of this video. There's a difference between the factual evidence of experts and their opinions. As the Supreme Court of Appeal said in HAL on behalf of MML versus MEC for Health Free State, as to the former, that is factual evidence given by experts, there is no difficulty in applying B versus Road Accident Fund. You'll remember I referred to B. We'll look at it later, but for now, you don't need to understand it, just understand what's being said in HAL. In applying B to the facts on which the experts agree, any more than there is a difficulty where the parties themselves reach agreement on factual issues. So as far as facts, when you conclude a joint minute, the court will be bound by the facts agreed upon. The opinions of the experts stand on a completely different footing. Unlike agreement on questions of fact, the court is not bound by such opinions. it is still required to assess whether they are based on facts and are underpinned by proper reasoning. In other words, the court still has to check whether those opinions are properly reasoned. Now, I'm not sure if any of you can see that there might be a problem here to do with the timing, to do with causation. Consider the position. Do you agree with what was found by the full court at this stage? Maybe stop, review the facts and consider whether you're in agreement or not. And then we'll have a look at what the Supreme Court of Appeal found. The Supreme Court of Appeal said, in summary, the position in regard to agreements between experts is as follows. 1. If they agree on issues of fact and the appropriate approach to technical analysis, the litigants are bound by those agreements, unless they have been withdrawn in circumstances where no prejudice results, or any prejudice can be cured by an adjournment or other means. Let's not worry too much about the exceptions. The general rule is in bold. If they agree on issues of fact, the experts agree on issues of fact and the appropriate approach to technical analysis, the litigants are bound by those agreements. 2. If the experts have reached agreement on a common opinion on a matter within their joint expertise, that is merely part of the total body of evidence. The court must still determine whether to accept the joint opinion. The existence of that agreement between the experts will not ordinarily preclude evidence that qualifies or contradicts their opinion unless the case has been conducted on the basis of the agreement and the admission of that evidence will prejudice the other party in a manner that cannot be cured. Again, let's not worry about the exceptions. The important bit is in bold. If the experts have reached agreement on a common opinion on a matter within their joint expertise, that is merely part of the total body of evidence. The court must still determine whether to accept the joint opinion. 3. If the parties choose to place an agreed minute before the court reflecting both shared opinions and areas of disagreement, and do not call the parties to the minute to deal with the areas of disagreement, the minute will do no more than reflect that there's disagreement on the point. In other words, if they put a minute before the court, some things are agreed, others are not agreed. All the minute does is it shows that there's disagreement on those certain points, if the witnesses aren't called. If they fail to, while it is for the parties to determine which witnesses they call, if they fail to call the authors of a joint minute, they cannot object when other witnesses express views that qualify or dissent from the views in the minute. In other words, if there's a joint minute and there's agreement on certain aspects and disagreement in other aspects, or on other aspects, and the author of the joint minute is not called, they can't object if evidence which contradicts what's been agreed in the joint minute is led, because the joint minute is not binding with regard to areas relating to shared opinions. So, in other words, the joint minute then is not the last word in regard to shared opinions where there are areas of disagreement. The Supreme Court of Appeal held that the most obvious misdirection by the full court was its failure to factor into its analysis of the facts the catastrophic crashing of Miss S at the commencement of the caesarean. By all accounts, this placed Miss S's life in danger and must have severely compromised the blood and hence oxygen flow to SS. Aligned with this uncontested evidence was that of the radiologists, which identified the cerebral palsy as having resulted from an acute, profound hypoxic ischemic injury, rather than a partial prolonged injury. It was not in dispute that the former type of injury is associated with a sentinel event. The court therefore found, bearing in mind the above, all the facts and the full court's failure to take into account certain facts, in particular the catastrophic crashing of Miss S. Consequently, the Supreme Court of Appeal found that the reasonable possibility was that the sentinel event that ultimately caused the brain injury was Miss S's adverse reaction to the spinal anesthetic. So now, that case, the consequence of this is that the case is not as strong as what the full court had found it to be. The Supreme Court of Appeal also found, as if that wasn't enough, that there was no evidence to support the conclusion that proper monitoring prior to the operation would have averted the brain injury, i.e., causation had not been established. The opinion of the experts, which was endorsed by the full court, was based on the assumption that there had been proper monitoring, the assumption that had there been proper monitoring to identify ongoing fetal distress, the caesarean would have been performed at 21:34 or soon thereafter. However, and we saw this assumption ignores the evidence that was before the court. When Ms. S was first examined at 21:34, the only doctor at the hospital was unavailable because she was in theatre with another patient. For obvious reasons, it was never suggested that the nurses who examined her could have made the decision that a caesarean section was necessary, and without the say-so of Dr. Marikane, put that process in motion. So we see that there was an assumption made by the experts, which in fact, when the court heard all the evidence, was not supported by the full body of facts. The Supreme Court of Appeal went on to say Dr. Marikane was the only one who could have made that decision, and she did so immediately after she examined Ms. S at 22:50. Thereafter, on the uncontested evidence, it was necessary to summon Dr. Mlandu, who was 30 to 40 minutes away, prepare Ms. S and the theatre for the operation. The Supreme Court of Appeal then makes the following important finding. On the totality of evidence then, the caesarean section could not have been performed earlier, even if the nursing staff had carried out regular heart rate monitoring. In other words, contrary to the conclusion of the full court, the evidence did not establish that but for the substandard monitoring in labour, the brain injury would not have occurred. Thus, causation was not established. I'll just add that the test for causation is whether but for the conduct we would have had the same result. And here's a nice example of the application of whether causation was proven or not. So what the Supreme Court of Appeals found is that when you look at all the facts, the plaintiff, the appellant in the Supreme Court of Appeal, had not established that had it not been for the substandard monitoring in labour, the brain injury would not have occurred, because there was still this tremendous delay, and then there was the crashing which occurred after that. And for those reasons, the Supreme Court of Appeal found that causation had not been established. So, in the result, the court found that there was a demonstrable misdirection on the part of the full court in assessing the prospects of success of the plaintiff's appeal. It failed to consider the total body of evidence in reaching the conclusion that causation had been established. Accordingly, the full bench's decision to refuse to strike the appeal from the roll because of the prospects of success could not be justified. It followed that in the proper exercise of its discretion, the full court ought to have refused condonation and reinstatement of the appeal and struck it from the roll. In the result, the court made the following order. The appeal was upheld with costs, including those of 2 counsel. The order of the full court was set aside and replaced with the following order. The appeal is struck from the roll with costs, including those of 2 counsel where so employed. Well, that's a thorough analysis of the case. It is a very good example of how joint minutes work, how joint minutes fit in with all the surrounding evidence of the approach which the courts should take to expert evidence, and crucially, the question of causation within cerebral palsy cases, and how it is extremely dangerous to simply assume that what's contained in the joint minutes, even where there's agreement between experts, is simply going to be accepted by the court. Remember the key distinction: where there's an agreement as to the facts, the court will be bound generally. There are 1 or 2 exceptions. You can have a look at those exceptions, but as a general rule for expert witnesses, when you conclude your joint minutes, bear in mind, if you're agreeing on questions of fact, that's an end of the matter. But however, if you're agreeing on questions of opinion, the court will still need to scrutinize that opinion in the context of all the facts of the case and decide whether that opinion is correctly held or not, as happened in this matter. I hope that you found that useful. I know the video is a bit lengthy, but I think it's worth it. There are a number of very, very central concepts locked up in this video, and a decision from a very high court, and demonstrating these concepts actually in action. Thank you for your time, and I will see you in the next video.